All right, good afternoon, everyone. Hope you all are doing well. And the reset date for SAP will be November 8th. And we'll be ready to go as soon as courtroom 2 is ready to go. Good afternoon, courtroom 2. Are we ready to proceed, courtroom 2? You all hear me? You all can't hear me?
I can hear you, Judge.
Oh, okay.
I'm right here, Your Honor. I'm sorry.
Okay.
This is Mr. David Houston.
Good afternoon, Your Honor. Regarding Mr. Houston, I am appearing on his behalf today. I did request an evaluation by Ms. Amin Williams to occur, and I just sent a message to the courtroom regarding that. Ms. Amin Williams is trying to connect with Mr. Houston, so I would ask that we hear his case later in the calendar.
Okay. Can we take someone else while we are waiting for someone to speak with Mr. Houston?
Hey, Houston. Oh, we'll sit back in there and third row. You not feeling well?
I think she's not eaten or slept or anything.
Okay, I need to go to the third row. Sit down. Come on. Your Honor, this is Mr. Octavius Sumlin.
Okay. Good afternoon, Mr. Sumlin. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 007292F with possession of a pistol or revolver by a person under the age of 18. Is there a history, Mr. Howard?
No.
Good afternoon, Ms. King.
How you doing, Your Honor?
I'm doing well, thank you.
This offense occurred on October 24th. Officers were dispatched to a fight call at 946 Martin Luther King Jr. Drive Northwest. Upon arrival, they met with the other officers that were already on scene, and they told them that there were two groups of Black males getting ready to fight, and one group was being more belligerent than the other and refused to leave the location. The defendant was part of that group. They also told the officer that responded that one of the males had a firearm. At that point, they approached the three males, who one was the defendant, the other was Quidricus Cullins and Quentin Welch. All three were detained at that time. They spoke with them and ultimately decided to detain them. Search incident to arrest, a firearm was found on the possession of the defendant, who is 17 years old at this time. And at that point, he was charged with possession of a firearm while under the age of 18. While the defendant does not have a criminal history, the state is very concerned that a firearm was in the possession of someone getting ready to fight. That situation could have gotten really out of control. For that reason, the state is requesting a $5,000 surety in this matter. We're also asking that he has no further contact with his co-defendants, Quadriquis, Kwydrequis, last name Cullins, as well as Quentin Welch, Quintin, last name Welch. Stay away from the incident location and no drugs, alcohol, or weapons while out on bond.
Good afternoon, Ms. Kim.
Yes, Your Honor. Mr. Sumlin is 17 years old, Your Honor, and he was born and raised here in Georgia. And I was able to speak with his mother, Christina Sumlin, who's willing to co-sign for his bond, and he does not have any employment. He is 12th grade in Atlanta Public School, high school, and his GPA is 3.0, and he dreams to be a boxer. He's very athletic. His favorite subject is mathematics, and he wants to go back to school. We would like to request for signature on bond. This is his first offense. There was not any violence that actually occurred. We would like to request for signature on bond. Also, he has a lung condition that he has a hard time to breathe, so he does need to have a continuous medical attention. Thank you, Your Honor.
Where is he in school?
Atlanta Public School,
What grade is he in?
12th grade, Your Honor.
Ms. King, were those other two young men arrested?
It's not clear from the warrant, Your Honor. Let me see if I can find more information. No, they were not. They were undetained, and only the defendant was arrested due to him being underage with a firearm.
Do you know whether or not, and I guess you probably wouldn't. I don't want to set him up for failure, because if he goes to school with these two other young men, then they necessarily might have to have some type of contact, whether it's in the hallway or whatever.
Well, Your Honor, one of them, Quadriquis, his birthday is 2001. So I don't think he would still be in high school. But the other gentleman, his birthday is 2005. So it's highly likely that they do attend together, Mr. Welch.
May I please ask my client whether they also go to the same school or not?
Yes.
Mr. Sumlin, would you please unmute the courtroom too? Mr. Sumlin, do you go to school with those two individuals?
No, sir. I'm at No Mountain.
Okay.
All right. So it's going to be a $5,000 signature bond through the jail. He's going to have to have his mother sign him out as a co-signer. He is going to have to stay in school. He's going to have a curfew from 9 p.m. to 6 a.m. He's not to have any drugs, alcohol, weapons while out on bond, and he's not to have any contact with Mr. Cullins or Mr. Welch. All right, I'm going to let you out, Mr. Sumlin, but if you violate any of these bond conditions, then you're going to be right back where you are, okay?
Your Honor, may the state request that is through pretrial services due to his age and the gravity of the offense. The state is requesting that the bond be through pretrial services.
Yeah, we don't really do pistol charges and misdemeanor or felony. So that's why I wasn't a recommendation through pretrial.
I understand, Mr.
Your Honor, his mother just came into the courtroom. She's in the galley.
Okay, if you can bring her up for me, please.
Not a problem.
Good afternoon, Ms. Sumlin. I'm Judge Eric Morrow. I have just completed the bond for your son on this matter. I am releasing him with you as a co-signer. It's my understanding that that you've agreed to sign him out. Is that correct?
Yes.
All right, and you should know that he also has a curfew. He is to be in by 9 p.m. and he can't leave until 6 a.m. All right, so he needs to have a curfew. He is to stay in school. He is to go to school each and every day as school is in session. He's not to have any drugs or alcohol or weapons while he's out on bond, and he's not to interact with these two young men that he was with on the 24th. He's also to stay away from 946 MLK Drive. Okay, do you have any questions for me?
Oh, no.
Okay, so I'm releasing him with you as a co-signer.
Okay.
All right, good luck to y'all.
All right.
Judge, what's the mother's first name?
Christina, CHRIST. Christina, CH.
And Your Honor, just to get clarification on this, you're releasing him through the jail or through pretrial?
With his mother as a co-signer.
I'm sorry, your audio went out. I didn't hear that first part.
Okay, yes, I'm releasing him through the jail with his mother as a co-signer.
Okay, and the state would really just renew our request. Since the court can order pretrial to supervise, we would really urge the court to order pretrial to supervise him, given his age and the severity of the offense.
Okay, Ms. Kim?
Court already made a ruling. I would like to keep that as is. I checked it, actually his school website. He gave me the login ID and password to check it, and he has no absence, no tardiness. He's a good student at school.
Okay, I'm gonna leave it as it is.
Thank you, Your Honor.
I'm not your objection. Have next. Who do we have courtroom two?
We got position number 2, Ms. Martha Butler.
Good afternoon, Ms. Butler. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 007278F with theft by shoplifting. Is there a history, Mr. Howard?
6 total. Last arrest was back in July, false report of a crime. December 2020, shoplifting.
I didn't know it was shoplifting, Your Honor.
March 2020, reckless conduct. 2019 FTA for suspended license. And a 2019 shoplifting. That 2019 shoplifting was NOD. And she got an FTA warrant from state court as of June 1st. Yes,
For what charge?
I don't know. It don't say.
Have
It doesn't say on this warrant. You got it?
I
All
do.
right. Okay.
Good afternoon, Ms. Duncan.
Good afternoon, Your Honor. That FTA warrant is for case 22 CR 001112F. It's a dormant bench warrant for the reckless conduct arrest. This defendant missed arraignment back in June of 2022 before Judge Richardson. She was out on a $2,400 surety bond at that time. Would Your Honor like me to proceed?
Yes, please.
Okay, this offense did occur on October 14th, 2022 at the corner market located at 3332 Colville Avenue in Hateville, and Colville is COLVILLE. In this instance, the defendant was with another party, Timothy Collins, who was already in custody. They went into that location, and the defendant, Ms. Butler, went into the store, took several items from the store, including alcoholic beverages, laundry detergent, and cups of coffee, and put those things in her bag and walked out of the store. These events were captured on video surveillance of the store at that time. And that video footage was shown to officers upon their arrival at the store. We're going to be concerned about the risk of reoffense in this case, given that this defendant does have several theft by shoplifting arrests in her history, as well as the FTA recently in 2019, as well as the FTA in 2022 for the current case that I just put on the record. We also have somewhat of a concern about this defendant's likelihood to respond to the legal process. This defendant has 6 or 7 criminal cycles, as pretrial has indicated, and has continued to reoffend while being out on bond, Your Honor. So in that instance, Your Honor, we think that a $1,500 surety is more than reasonable in this case, and stay away from that corner market in Hateville. No alcohol, drugs, and weapons, no further violations of Georgia law, a theft class, and stay away from the co-defendant in this case. Nothing further from the state.
Good afternoon, Mr. Premier.
Good afternoon, Your Honor. My client is 69 years old. She is currently on Social Security. She has expressed to me that she has several illnesses, pretty significant. As a matter of fact, she told me that on the day in question, she was just coming from the hospital. She had collected her Social Security money and she had stopped with her soon-to-be husband to do some shopping. She denies that she shoplifted, Your Honor. She said she was just there getting some things because they had just planned to go home to relax because she had just gotten out of the hospital. I would ask the court to take into consideration that any history my client may have had is for fairly minor things. She is quite old and also quite feeble. She has illnesses. She's just not, it's not a good thing for her to be in jail because she takes medication and so on. And she tells me that she suffers from diabetes, which can sometimes go into critical stages. And she had a critical stage on that very day. And that was the reason why she had been in hospital, Your Honor. I understand that also that these are just allegations. She denies them. She actually told me that was the day she received her money and they were just shopping. Based on these facts, Your Honor, her version of events and what is alleged, I would ask the court to give her a signature bond. She's 69 years old. I do not think she's a danger to society, and she is also not very well. Thank you, Your Honor.
As stated for the record, Your Honor, there was surveillance video footage of her putting those items in the bag and walking past all points of sale without paying for them. That was given to officers by the store clerk at that time. It was a Mr. Raju Daradia, that's R-A-J-U, last name D-A-R-E-D-I-A. So we understand the defense's sentiments, but there appears to be video footage of this incident that officers were able to review. Nothing further from the state.
Be a $3,000 signature bond through the jail. Stay away from the corner market in Hateville. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Butler.
Thank you, Your Honor.
I'm sorry, Your Honor, what was that bond amount? I apologize.
3,000 signature through the jail.
Thank you.
Okay, did you get that?
You okay? Yes. Can you get up? Good job.
Come on, Ms. Butler.
Next, Your Honor, we have position number 1, Ms. Brown.
Good afternoon, Ms. Brown. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video? Thank you. You've been charged in case 22 CR 007285A with battery. Is there a history, Mr. Howard?
Yes. She was she got a 2014 suspended license, another 2014 suspended license, history out of Virginia and California. She had an 03 robbery out of California. Charges were dropped. 2008 failure to appear, driving without a license. 2008, it just says warrant. 2010, giving false name to a peace officer and failure to appear. Virginia 2013 larceny. That was a conviction. Hold on. It says unauthorized use of animal vehicle larceny. Yeah. So that was a conviction. 2013 out of Virginia. That's it.
Yes, Your Honor, in this case, it occurred on September 2nd, 2022 at 6990 Bethesda Way, that's BETHSADIA Way in Atlanta. The victim in this case is Eric Crooms. It's ERICCRUMES. And in this instance, the victim reported to officers at the time that the defendant attacked him while he was in his driveway after returning from a trip to Mexico, where he had indicated that he no longer wanted to be in a relationship with her. When he got home, she ran up to his car and apparently exchanged some words with him about a vehicle. And then she tried to reach into the car and she began scratching and grabbing and pawing at his face and neck and the back of his neck area, which resulted in the victim having 2 large lacerations that were visible to officers on his neck area. Our office was able to speak with the defendant's ex-boyfriend, and he stated that he no longer is in a relationship with her. He wants no contact. They share no children and would like for her to stay away. He did indicate that he may be on Zoom today, but Your Honor, we have some concern in this case about the defendant being a flight risk, given that there are FTAs in the history. And while we do recognize that there is limited criminal history in this case, given the violence alleged and the injuries that did occur that were visible and noted by the officers, we believe that a $3,000 surety is more than reasonable. No further contact with the victim in this case, or stay away from that incident location, because that is the defendant's ex-boyfriend's location. He indicated that he still lives there. He wants her to stay away. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Ms. Gant?
Thank you, Your Honor. Ms. Bernasia Bram is 34 years old. She has been in the Atlanta, Georgia area for 13 years. She is married and has been so for the past 10 years. She completed high school and she is currently unemployed. She has been so since 2022. The summer of 2022, Your Honor, she denies the allegations, and I would ask the court to take judicial notice of the fact that 6990 Old Bethsaida Way is in Riverdale, Georgia, and that is information that is easily ascertainable from UnitedStatesZipCodes.org. So I would ask that Your Honor dismiss this case for lack of proper venue, or in the alternative, grant a signature bond, Your Honor. And we are unopposed to any no contact and stay away provisions. Thank you, Your Honor.
All right, it's going to be a $3,000 signature bond through pretrial 1-day anger awareness, stay away from the Bethsaida Way address, no further contact with Mr. Crooms, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Brown.
Thank you, Your Honor.
Thank you.
Next, y'all, you got position number 7. It's a private attorney case. Ms. Pasha.
Good afternoon, Ms. Pasha. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do.
Thank you. You have been charged in case 22 CR 007290G with battery. It's my understanding from pretrial that this is Ms. Pasha's first arrest. Ms. King?
Yes, Your Honor. This offense occurred on September 23rd of this year. Officers responded to 384 North Yards Boulevard Northwest. Upon arrival, they met with the victim in this case, Ananda Harris, ANANDA, last name traditional spelling. She stated that while she was inside, she put her drink on the table where the defendant was sitting. The defendant, I guess, had an issue with that and asked her not to do so. but the victim, walked away minding her business. All of a sudden, while her back was turned, the victim stated that she felt something hit the side of her face and noticed that she was bleeding. And it was an item that the defendant threw at her. So at that point, the victim contacted law enforcement. And when law enforcement got there, they spoke with the defendant and she stated that this probably happened. There was also a chicken skewer involved, and that is what the defendant said likely hit the face of the victim that caused the laceration and the bleeding. While the state understands there's no criminal history here, throwing a glass or a chicken skewer at somebody could have caused a very serious injury. Her eye could have got poked out. For that reason, the state is requesting a surety bond in this case, a $2,500 surety. We're asking for no further contact with Ananda Harris, a stay away from the 384 North Yards Boulevard Northwest address, and no drugs, alcohol, or weapons while out on bond.
Good afternoon, Mr. Jerome. Is this your case? You're on mute.
I apologize. Can you hear me now?
Yes, I can. Good afternoon.
Yes, it is. Good afternoon. So yes, just to go over the facts briefly. So Miss Harris did place a plastic cup on Mrs. Pasha's table, and Miss Pasha did tell her not to place the cup there. Miss Pasha knocked the cup off the table onto the floor. Miss Harris is the one who picked it up and tried to throw it at Miss Pasha, who knocked the cup back and also had a shrimp skewer in her hand. And she knocked the cup back. The cup did go when Miss Harris threw the cup at Miss Pasha, and Miss Pasha knocked the cup back. It did hit her. However, Miss Pasha said that she wasn't sure if it was either the chicken skewer or the cup that cut Miss Harris. Nonetheless, I actually spoke to the officer that responded to this, and he did not file these charges. Miss Harris at a later date went to a different precinct to an officer who did not appear on the scene and filed another police report, and that officer is actually the one who filed charges. There were witnesses to this original incident who corroborated Mrs. Pasha's telling of events, which is why the original officer did not file the charges, because he essentially determined that Mrs. Harris was the aggressor. Now, Ms. Harris, went about, finding a way to get this warrant issued, and now Ms. Pasha is incarcerated. Just to tell you a little bit about her, Ms. Pasha is a general manager at a hospitality group that handles, hospitality for building restaurants and other hospitality venues. She's a photographer. She has a nonprofit organization called a Clap for a Cause. She attends church with her mother and her grandfather at United Methodist. She is she's also involved in other nonprofit organizations in the community. She was born here in Atlanta. Her whole family lives here in Atlanta. She hasn't had any contact with Miss Harris since this event has taken place. We're talking about an upstanding citizen who's never had any issue before in the past. This was obviously just, there's something here that's not lining up with what Miss Harris is saying about Miss Pasha. That being said, Your Honor, we'd like the legal process to play itself out. And in order to do so, we're also asking that Miss Pasha be given an OR bond. I'm not sure how the court would refer to it now as signature or signing for yourself. However, we'd just like her to be released on her own recognizance. Thank you.
Does Miss Pasha and Miss Harris, are they acquainted with each other? Do they know each other? Or
they do not know each other. They were at the gathering spot, which is, from what I understand, a city club. And Miss Harris, for no apparent reason, just came and placed garbage onto Mrs. Pasha's table. And one of those things was that the cup that Miss Pasha knocked onto the floor.
Okay. It's going to be a $2,000 signature bond through the jail. No further contact with Ms. Harris. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond.
All right. Thank you. May I be excused?
Yes. Good luck to you, Miss Pasha. Have a good afternoon, Mr. Jerome.
Your Honor.
Thank you.
Yes.
May I speak?
Thank you so much.
Yes, who's speaking?
This is Ananda Harris.
Yeah, no, I'm gonna
Harris.
object.
I allow people to speak in this courtroom. I've already made my determination, Ms. Harris. I'm happy to give you the opportunity to speak. You'll have to raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down and just know that this is just a bond hearing today. This is not to determine the truth or the falsity of any allegations, all right?
Okay.
All right.
Well, I just briefly want to say that everything that was said was categorically false. And I am a federal investigator, and these things were complete lies that this attorney just said. So that's all I have to say right now. But thank you for letting me speak.
Yes, of course. And litigate this as it goes further, okay?
Okay, thank you.
All right. Y'all have a good day. Thank you.
Thank you.
What was that bond amount?
$2,000 signature bond through the jail.
Appreciate it.
Okay.
I told you, I'll let you know. Next, we're gonna go to Mr. Troutman.
Okay, that's on the add-on calendar, position 1 and 2.
Yes.
Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 007293F with theft by shoplifting, and in case 22 CR 007294F with willful obstruction of a law enforcement officer and shoplifting. Is there a history, Mr. Howard?
43 total. Last was 2021. Obstruction. That was a conviction. 2020 shoplifting, obstruction, battery, arrest. 2020 probation. Underlying charges crossing guard lines, possession of marijuana, and battery. 2020 simple battery, family violence, that was dismissed. No, regular simple battery, that was dismissed. 2019 another probation. He got probation convictions from 2019. 2019 shoplifting arrest. 2018 probation. I had a 2017 possession of cocaine that was dismissed. 2017 forgery in the 4th. He was convicted for the battery in 2017, along with the marijuana and crossing guard lines. Got a criminal trespass conviction 2016. 2015 obstruction, simple battery against police. Forgery in the 4th degree conviction 2015. Another 2015 arrest for forgery in the 4th. That was a conviction as well. Theft by taking conviction 2014. Got a burglary that was dismissed from 2012. 2012 shoplifting conviction. Another 2012 shoplifting conviction. Burglary conviction from 2008. And that was 3 counts of burglary out of DeKalb County.
Thank you. Good afternoon, Mr. Lynn.
Good afternoon, Your Honor. Would you like me to make my arguments for both cases together, or would you like to go one by one?
You can start with position 1, and once you complete that, then you can go to position 2.
Yes, Your Honor. On October 18th of 2022, Officer Davis with the Atlanta Police Department was dispatched to Home Depot at 650 Ponce de Leon Avenue in Atlanta, Georgia, for a shoplifting call. Upon arrival, Officer Davis met with the loss prevention officer, Daniel. He stated that a African-American male wearing a blue hoodie, blue jeans, and a duffel bag went into the back of the store, took a nail gun and a propane tank and placed them inside his duffel bag. The defendant exited the lawn care store without paying for the items. Mr. McDaniel attempted to approach the defendant in hopes that he would return the items, but he refused. When Mr. McDaniel tried to grab the duffel bag, the nail gun fell on the floor and the defendant was able to run away with the propane tanks. Upon officer arrival, the defendant was not there, but they did have the incident on surveillance footage. And this also ties into his second shoplifting arrest, and that was how they were able to identify him on the October 18th date, Your Honor. For this case in particular, the state is requesting $1,000 surety bond, stay away from the incident location, no alcohol, drugs, or weapons while out on bond. Due to the defendant's history of shoplifting and theft charges, he does pose a danger to the community and the property of others. He poses a risk of reoffending due to his convictions. He is currently on a suspended sentence for that 2021 obstruction conviction. A part of that case was initially an arrest for theft by shoplifting at the Staples that's on Ponce de Leon, which is the same area where this incident occurred. We also saw failure to appear arrest from 1999 and 2001. So the state would argue that he also shows a likelihood of not appearing for court in the future. Due to that, the state is requesting that $1,000 surety bond, Your Honor, on this case. Nothing further from the state.
And position 2.
Yes,
No,
Mr.
yeah.
Yes.
I'm sorry, did you do both positions, Mrs. Sillett?
I did not, Your Honor. I'll go over the facts really quickly for position number 2, but my argument will be the same. And my bond amount, my bond request is $1,000 surety bond on position number 2 as well.
On each charge or 500 per charge?
$1,000 on each charge, Your Honor.
Okay, thank you.
On position number 2. So on October 23rd, 2022, Officer Dawson with the Atlanta Police Department was stationary at the Home Depot at 650 Ponce de Leon Avenue in Atlanta. Upon being at that location, he observed employees running out of the store towards a patrol vehicle, and they were yelling and pointing at the who was running through the parking lot with an item in his hand. The loss prevention officer, Mr. McDaniel, yelled that the defendant had stolen an item. Officer Dawson began to pursue the defendant at that time and engage in a short foot pursuit. He was finally able to apprehend the defendant. The defendant refused to place his hands behind his back in order to be arrested after Officer Dawson requested him to do so. Officer Dawson was finally able to get him in handcuffs, and once he tried to place him in the vehicle, the defendant attempted to block the door of the vehicle from closing and also kicking the door at that time. Officers were finally able to successfully arrest him. And at that time, Mr. McDaniel, the loss prevention officer, made officers aware that on that day, the defendant had shoplifted a drill from the store. And he also identified him as the defendant who had shoplifted on the previous case on October 18th. And they identified him through photos and surveillance footage. The same argument for this case, Your Honor. The state just reiterates its argument that the defendant poses a risk of reoffending, again, due to his history. Nothing further from the state.
Thank you. Ms. Kim?
Yes, Your Honor. Mr. Troutman is 42 years old, Your Honor, and he is from Atlanta, Georgia. His children are all grown up. However, he does not have anybody who can bail him out from the jail. He has no employment. And indeed, I already emailed to social worker services so that he can get housing resources. And also, he's interested and willing to go for a rehabilitation. So we are seeking for resources for him. And his medical condition to have a seizures, epilepsy is kind of dangerous. So we would like to make sure that he is watched very well, carefully at the jail. I strongly prefer him to get signature on bond so he can get out of the jail. And yet, if Your Honor is not inclined to give him a signature on bond, $3,000 bond total will be like a no bond for him. Even 1,000, I believe that will be considered as a no bond for him. So maximum $500 good bond, Your Honor. Thanks.
All right, so for position one, it's going to be $1,000 good bond. Stay away from the Home Depot on Ponce, and no drugs, alcohol, weapons while out on bond. For the second case, the willful obstruction is going to be a $500 good bond. The theft is going to be a $500 good bond, making for a total of $1,000 good bond. And stay away from the Home Depot on Ponce, no drugs, alcohol, weapons while out on bond. He's also to have a social worker visit him if he is not released, or if he doesn't make bond by the state all-purpose calendar. Ms. Kim, I'd like for the social worker to have already seen him so that I can address him at that time.
Sure. Thank
Yes.
you, Your Honor.
Ms. Falk?
Your Honor, understanding how much havoc this wreaked yesterday, I would point out that he is eligible for mental health court. And I have emailed the mental health court to let him know what the bond was, and that he has no previous history which would make him ineligible. So I'm assuming they will be sending somebody out to follow up with him.
Okay, and so you want, Ms. Kim, would you like him placed on the mental health calendar instead of the
Sure.
SAP calendar?
Yes.
Okay, all right, so if we can place him on the next, thank you, Ms. Falk, on the next mental health calendar, that would be helpful. Thank you.
And I believe that's going to be the 27th. And we also usually place him on the SAP calendar just in case he decides not to avail himself of the services.
Okay.
Okay.
Thank you. All right,
Thank
good
you.
luck, Mr. Troutman.
Next, we got position number 4, Mr. Gomes.
Good afternoon, Mr. Gomes. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You've been charged in case 22 CR 007287G with simple battery family violence. Is there a history, Mr. Howard?
9 total. 2019. Possession of a controlled substance. 2019 FTA shoplifting. 2018 obstruction. Theft by shoplifting, giving false name. 2018 shoplifting NOLO. 2017 misdemeanor possession of marijuana. 2016 shoplifting dismissed. He was arrested in Florida on an out-of-state fugitive warrant. That was in 2019, probably for the Georgia stuff. That's all.
Yes, Your Honor, this incident did occur on July 29, 2022 at 950 Marietta Street Northwest, apartment 4319. The victim in this case is Autumn Crump, AUTUMN, Crump, CRUMP, who is the parent of the same child as the defendant. In this case, officers responded to a dispute call. When they arrived, they met with Ms. Crump, and she stated that her child's father had attacked her. They had had a verbal argument about the care and transport of the child, and then that argument became physical when the victim in this case, Ms. Crump, stated that she did not feel comfortable with the defendant taking the child on that particular day. He became irate and he pushed her to the ground. At that time, we do have some concern about the risk of reoffense here, Your Honor, given that the dispute arose over the care and custody of the child. They're always going to share this child together, so there's some potential for reoffense if concerns are raised about that child in the future. We do have some concerns about flight risk, given that this defendant had a fugitive from out-of-state fugitive arrest and a recent FTA in their record, as well as a concern about the likelihood to respond to the legal process, given that this defendant is no stranger to the legal process, having 8 cycles and being a multi-state offender. We believe in this case that a $2,500 surety is more than reasonable. We're going to ask for no further contact with the victim Our office was not able to make contact with her, and out of abundance of caution, that is the state's recommendation, we're going to ask for a third-party child contact. Stay away from the incident location. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Ms. Gant?
Thank you, Your Honor. Mr. Marquise Gomes is 24 years old. He has been in the Atlanta, Georgia area for 14 years. He has family here, including his parents and his brother. He also shares a 2-year-old son with the complaining witness, Ms. Autumn Crump. Your Honor, my client tells me that Ms. Crump now lives in Chicago. I did have the occasion to speak with her regarding her desire for contact. She wants to have contact with my client, as does my client. Mr. Gomes completed high school. He also studied human resources in college. He is currently employed at Petro Truck Stop. He has been in that position for four years. He strongly denies the allegations, Your Honor. I do acknowledge my client's history. However, Your Honor, I did not hear about any convictions for violence, and any and all FTAs are resolved. And 3 years ago, according to the report that I received, he is recommended for a signature bond. Therefore, I am requesting a signature bond on his behalf. If Your Honor determines that he's ineligible, then I would ask for a low bond, much lower than $2,500 for simple battery family violence. Of course, he's presumed innocent. And finally, Your Honor, we are requesting no violent contact, Your Honor. And if Your Honor orders no violent contact, then we are unopposed to third-party transfer. Finally, Mr. Gomes informed me that the incident location, 950 Marietta Street, Northwest 4319, is an old address. Neither party lives there now, Your Honor. Thank you.
And since we have not had the opportunity to speak with the victim in this case, we would object to that. We understand the defense's sentiments. However, out of an abundance of caution, we would ask that the court grant the state's recommendation. Nothing further.
It's going to be $1,000 good bond. No further violent contact with Ms. Crump. Stay away. No further violent contact with Ms. Crump, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Gomes.
Thank you so much.
Thank you, Your Honor.
Thank you.
All right, who do we have next?
We have position number 5, Mr. Hopkins, Jarrell Hopkins.
Good afternoon, Mr. Hopkins. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon, sir. You have been charged, Mr. Hopkins, in case 22 CR 007288D with criminal trespass and damage to property. Is there a history, Mr. Howard?
6 total. Last was 2016, possession of a firearm by convicted felon. Before that was a 2016 driving without a valid license, possession of a firearm by convicted felon. Drugs not in original container. The driving was dismissed. I have to look up the other charges. 2016 aggravated assault, simple battery. The ag assault was dismissed. The simple battery was a conviction. See, 2013, he had a CWAC charge that was non-prost on here, but he did go to prison for something. He had a simple battery from 2012 that was not prosecuted. I have to pull that 2013 case, unless the state got it.
Ms. King?
Yes, I believe the 2013 case Mr. Howard is referencing is a false imprisonment, which he did serve time for. Furthermore, Your Honor, the defendant has an open felony case, 22 PF 007277, possession of firearm by a convicted felon and theft by receiving. Last I saw, there was no bond. That may have changed by now. This offense occurred December 11th, 2019. The defendant went to the home of Ronisha Edwards, RONNIESHA, last name traditional spelling, located at 1033 Hollywood Road, Northwest in Atlanta. They got into an argument when she would not let him in her home, he got upset and threw a bike at her windshield, which cracked her windshield. We have been in contact with this victim. She stated they were in a relationship at that time, but they are no longer in a relationship. They have never lived together and share no children. She stated that she has not seen or spoken to him since this incident, and she no longer lives at the incident location. She states that she has gotten her windshield fixed since then, and it cost around $300. The state is requesting, well, there's currently a $1,000 surety in place. The state asked that it remains as set. I will still ask for no further contact, even though they haven't had contact since then, just in case he decides to want to contact her, especially since the state is moving forward at this time. A stay away, it would not be appropriate since she's not at that incident location anymore, but we are asking for no drugs, alcohol, or weapons while out on bond.
Oh, and he went to felony earlier. He got a $10,000 good bond for that charge.
And thank you so much, Mr. Howard.
All right, if it's all right with you, Ms. McLeod, it's gonna be $1,000 signature bond through the jail, no further contact with Ms. Edwards, and no drugs, alcohol, or weapons while out on bond. Does that suit you?
That suits me, Your Honor.
All right, good luck to you, Mr. Hopkins.
Okay, you good. Next, we have position number 8, Mr. Grant Pickett again in front of you, Your Honor.
Okay, Ms. McLeod, I believe that yesterday I heard Mr. Pinkett's case. I gave him a good bond, is what I believe I remember, and I wanted him to come back today so that he would have the assistance of counsel to speak on his behalf regarding that bond. Not that I would change it, but I just wanted to make sure that that I've heard everything that I would need to hear in that regard. And I wanted to make sure that if he didn't get out, that he had somebody here to represent him today. So I believe that's why Mr. Pickett is back. And you had the opportunity to speak with him?
I did, Your Honor.
Okay, Ms. King, can you go through the facts for me again and remind me as to what bond I placed on him yesterday?
And this is Mr. Pickett. I think
it was a $2,000 good bond, I believe, Your Honor.
Okay.
Okay. Yes, this offense occurred on October 23rd at the Starbucks located at 506 Moreland Avenue Northeast. The victim, Willie Harrison, contacted law enforcement. He was at the Starbucks earlier and he periodically stepped out to smoke a cigarette. And one time when he came back in, his bag was gone. Inside the bag was an Amazon tablet. He stayed in the area hoping to see either his bag or someone he saw inside, and he actually saw the defendant. He went up to the defendant and asked him about it, and he stated that, yes, he took the bag. The quote was, "It was my fault, I took the bag." At that point, law enforcement arrived, and he even went and spoke to the defendant, and he again admitted to law enforcement that he did take the bag. Before Miranda rights was read, no, I take that back. Miranda rights was read and he agreed to speak to the officer without the attorney present. And he said that he took the bag from the Starbucks and sold the Amazon tablet for crystal meth. He was offered medical services, but declined. The state did request a $2,000 surety due to his lengthy criminal history with 28 cycles. Furthermore, he has a 2017 theft conviction with similar facts. In that case, he stole a book bag containing an iPad, which shows a pattern, Your Honor. For that reason, the state feels the 2,000 surety is more than reasonable, and we ask that it remain as that.
Ms. McLeod?
Yes, Your Honor. My client tells me that actually what happened, that he just, he did take the bag, but he took it for safekeeping because he had seen the person he thought that they had left. When the gentleman asked him about it, he gave him back the bag and his belongings. And he did that with the police officers around. So he was surprised that he was still arrested because he said, yes, I had it. And he gave back the bag to them. My client tells me, Your Honor, that he has no one in Atlanta who can help him with a bond. So the fact that he has a surety bond means that he's going to be sitting in jail because he doesn't have anyone to help him. He is married. He tells him that he's estranged from his wife and she lives in another state, Your Honor. She lives in Texas. He has no one else here in Atlanta to help him to make bond. And given the fact that he says that he actually told them that he had the bag and in his mind he was just holding it because he thought the gentleman had left, he was just holding it for safekeeping since he was there. And when the gentleman approached him, he told him yes, and he gave it back to him. Your Honor, I don't believe his actions are so egregious that he should have been arrested there because everything was resolved, it sounded to me. Because he alleges that he did not take it with any malicious intent. He just took it because he thought it had been abandoned.
Does he have a place to live, Ms. McLeod? Does he have?
He says he does, Your Honor. He says he has a place to live, Your Honor. But it sounds to me like, other than a simple roof over his head, he doesn't have much going on.
Your Honor, I would just like the record to reflect that Ms. McLeod, that is not true at all. Law enforcement, he did not give the belongings back. In front of law enforcement, he said that he took the bag without permission and sold it for crystal meth, Your Honor.
I spoke to my client, Your Honor, and he tells me that he gave the belongings back. That is what he told me.
The client with 28 cycles with some moral turpitude charges in here, as well as theft charges in the past. So if we're going to take the word of a police officer or a defendant with 28 cycles, Your Honor.
I understand the counsel, but he is still presumed innocent.
I'm trying to do what I think is best for Mr. Pickett. And, you know, and from what I've heard, as far as if there is a drug problem, that problem's not going to get addressed if I put him back out. But if I leave the bond where it is, hopefully, if that is a problem, then we can get him some help. So I appreciate you speaking with him, Ms. McLeod. I wanted to give you that opportunity. I am concerned about the issue, so I'm going to leave the bond where it is. And if you want to have someone speak with him, or if you'll speak with him, Ms. McLeod, prior to that SAP calendar regarding that issue of a possible drug problem, then I'm happy to readdress it at a later time when we can possibly get him some help if necessary. Okay.
Yes, Your Honor.
Okay.
Mr. Pickett, is this in regard to your bond?
I'm at a loss for words because the first one, she even went back 7 years ago. I maxed out of prison over that tablet and that backpack back at public.
Mr. Pickett,
I gave that one back too. The person got hold. Just for the record, as God is my witness, that person got that back before I ever went, and I spent 5 years in prison waiting for my son. Now here we are again. Y'all aren't giving me a signature bond, and I just listened to all those cases before. Okay, so as God is my witness, that's fine. That's y'all's decision.
Mr. Pickett, the judge has already ruled on your bond.
I said, as God is my witness, have mercy on y'all. I'm not mad. Like my conscience is clear, so just don't worry about it. My conscience.
I'm going to be able to speak with you again, Mr. Pickett. So I have some.
And all the attacks I've received in this show, which they're little kids, they can't judge me, but they do shit like blindside me from nowhere all over the streets. It's the same thing in this fucking place. And he knows it, like, and I'm a gentle guy, but like, one day, like, I'm gonna have my day, Ms. King, and I don't have a dream. I'm gonna live it.
You may need a social worker also, Ms. McLeod.
Whatever, man.
Yes,
I've been in the city since '85, man. I've worked. I'm a tree man. I'm a tree lumberjack.
Come on.
Okay.
And I'm not mad at y'all. Y'all have a great day. I'm glad y'all get to live life. You know what I'm saying?
Listen, I'm gonna give you some sandwiches, right?
All right.
Okay.
And this is.
We're gonna revisit position number 10 again. Mr. Houston. He spoke to the social worker
All right, I'm sorry, tell me the name.
Mr. Houston, David Houston, position number 10.
Okay. Yeah, he's position number 6, I believe.
I'm sorry, yeah, I'm so sorry, position
That's all
number.
right. No, I just couldn't find
I'm
him.
tired today, I am tired. Forgive
I
me.
know you are. You've been working hard today.
Yeah, I've been running around all day.
I got you. Okay, so what are we doing with Mr. Houston? Ms. Gant, do we need a breakout? What do we need?
No, Your Honor, we do not need a breakout.
Okay, all right. Good afternoon, Mr. Houston. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. You have been charged in case 22 CR 007289J with reckless driving and fleeing or attempting to elude a police officer. Is there a history, Mr. Howard?
I got first arrest. He went to felony earlier. I think he got a $5,000 split bond. That's all I got though.
All right, Ms. King.
Yes, Your Honor. This offense occurred on October 24th at the Alpharetta First Baptist Church located at 44 Academy Street in Alpharetta. Officers were dispatched to a vehicle doing donuts and driving recklessly in this parking lot. Upon arrival, they saw the defendant in the vehicle reversing up the side driveway. The officer also noted that there were many vehicles and pedestrians in the area at this time. At that point, the officers went to attempt a traffic stop by turning on their emergency equipment. At that point, the Jeep started to drive head on with the officers and then went around and drove past him. The officer also noted that he was going at a high rate of speed in this parking lot with the vehicles and church staff present. The vehicle eventually came to a stop when he put on his sirens, Your Honor. Due to the defendant not having a lengthy criminal history, the state is willing to consent to a 5,000 signature bond through pretrial in this matter, but we are asking for a stay away from the Alpharetta First Baptist Church and no drugs, alcohol, or weapons while out on bond.
What's the breakdown?
It's $2,500 for each offense, Your Honor.
You have any objection to that, Ms. Gant?
No, Your Honor.
All right, so it's going to be $2,500 SOB through pretrial, making a 5,000 SOB through pretrial. Stay away from 44 Academy Street. Excuse me. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Houston.
Thank you, Your Honor, and Ms. King.
There you go.
Yeah, you can go to 3 South.
Okay.
I got position 3.
This is Mr. Dennison.
Yes.
I'm sorry. Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case read by video?
Yes.
Thank you. You've been charged in case 22 CR 007286 with criminal trespass and damage to property. Is there a history, Mr. Howard?
Dennison, first arrest for Dennison.
Okay. Ms. Duncan?
Yes, Your Honor, this incident did occur on September 2nd, 2022 at 1292 Beecher Street Southwest in Atlanta. In this incident, officers Strainer and Leonard responded to a dispute call. They met with the victim in this case, Todd, that's T-A-R-L, last name T-O-D-D. When they met with Ms. Todd, she stated to the officers that the defendant in this case came to our home. They got in an argument. She asked the defendant to leave. And when the defendant left, instead of just leaving the premises like asked, grabbed a wooded board from somewhere near the front porch and began to hit the window and shattered that window. And my apologies, I believe it's Todd. It's T-A-R-I. Hit the window, shattering that window, and then leaving the scene. Our office was able to make contact with Ms. Todd. She stated that she is the aunt of the defendant in this case. She stated that the defendant does not live at that location. She does not want defendant at that location and would like for the defendant to stay away. She wanted the court to know that that window has not been repaired and is still broken at this time. She got an estimate for that window to be fixed, and it's about $325 to repair that window. She hasn't had contact, doesn't want to have any contact. Given their familiar relationship, we do have some concern about the risk of reoffense if the defendant is allowed to go back around their aunt. Therefore, the state is going to be requesting, in recognition of the limited criminal history, a $3,000 signature bond through pretrial services, no further contact with Tari Todd, and stay away from the incident location, 1-day anger awareness, no alcohol, drugs, or weapons, and no further violations of Georgia law. Nothing further from the state.
You have any objections to any of that, Ms. Gant?
No, Your Honor, we are unopposed, and thank you, Ms. Duncan.
Okay, so it'll be a $3,000 signature bond through pretrial with the other conditions. Good luck to you, Ms. Dennison. Three South?
Go ahead, Judge.
Yeah, do we have, are you all gonna have anybody else for us?
I was told that threshold was waived.
Okay, if there is a waiver on Thrasher, what about position 9? Oh, position 12, Ricky Williams.
I was told that that's going to be a medical reset.
Okay, medical reset for position 12 until tomorrow, the 26th. And what about, are we going, Jessica Sheed?
She had bonded out.
Oh, she's bonded out, okay. So, and I think that covers everybody at the jail except for, we have a waiver, is that right, Ms. Kim?
Yes, Your Honor.
All right, thank you, 3 South, we appreciate it. All right, let's do position number 11. Is there a history for Mr. Thrasher? Mr. Howard?
He's 6 total. Last arrest was 2021, failure to appear. (2020) trespass, possession of drug-related objects. 2019 simple assault, not prosecuted. 2019 FTA for trespass. 2019 trespass conviction. 2019 criminal trespass obstruction. It just says transferred. That was from Hayville. 2019 trespass conviction. Had a 2017 battery DV, cruelty in the 3rd arrest. 2018 probation. Underlying charge was battery DV, so it's probably that one. That's 17 CR 018210 A as in Apple. 2013 theft by taking. 2013 theft by receiving. 2011 probation, burglary, entering auto, theft by taking auto. 2009 FTA for shoplifting. You want me to keep going?
You're good. Collect.
Yes, Your Honor. On October 22nd, 2022, Officer Davenport was dispatched to 1180 Virginia Avenue in Hapeville. That's a racetrack gas station. Upon arrival, Officer Davenport spoke with Ms. Newman, who was an employee at that gas station. She stated that at the time she believed the defendant was attempting to steal items from the store, and she approached him. Ms. Newman advised that the defendant to leave the store because he had already been previously criminally trespassed from that location on October 20th of this year. Ms. Newman advised that after she told the defendant to leave the store, he threatened her by saying, "Get away from me before I stab you." He also stated, "Leave me alone or I will kill you." Ms. Newman stated that she was frightened by these remarks, and that's when she called the police. And he was arrested at that time. Officer Davenport got out on the scene. Due to the defendant's prior history, the state would be arguing that he poses a risk of reoffending. He does have criminal trespass convictions from 2019. One in particular in 2019 is at the same racetrack location. And he also has FTA arrests from 2003, 2005, 2008, and 2009. So the state would argue that he poses a likelihood of not appearing for court in the future due to his prior FTA arrest. Due to the egregiousness of this crime as well, with the threats that he made to the employees at the racetrack, the state is recommending $1,000 surety bond on the criminal trespass charge and a $2,500 surety bond on the terroristic threats. No alcohol, drugs, or weapons while out on bond, and a stay away from the incident location, that 1180 Virginia Avenue in Hapeville.
Kim?
Yes, Your Honor. Mr. Robert is 50 years old, Your Honor, and he has all his family members here in Georgia. However, he does not have anybody who can bail him out. That's why he is still in jail, even though there is already bond set for $2,000 total, $1,000 for each charge. He is getting disability check. His education was up to 10th grade. And I actually requested social worker services to have a visit so that way they can have a BHET evaluation. And I would like to request for a signature on bond. And yet, considering his past histories, we would like to request have the current bond set as remain or maximum $500 per each charge, $1,000 good bond. Thanks.
And Your Honor, if I may add, I wasn't sure if you heard Mr. Howard because it kind of cut out. He has 56 arrests in total.
Okay, thank you.
Oh.
With the terroristic threats, $1,000 good bond, criminal trespass, a $500 good bond, so a total of a $1,500 good bond. Stay away from the racetrack on Virginia Avenue. No further contact with Ms. Newman. Social worker visit, and no drugs, alcohol, or weapons while out on bond. Okay.
Thank you, Your Honor.
Again, Ms. Kim, if you will have that social worker visit him before the SAP calendar, I'm happy to see what we can do with him at that point.
Thank you, Your Honor.
All right. Okay, I believe that completes the calendar. As soon as, I'm not sure if Mr. Jordan, are you gonna go over the calendar or?
It'll be me today, Judge.
Okay. Whenever you're ready.
Position 1 is a $3,000 sign-on bond through pretrial. Position 2 is a $3,000 sign-on bond jail. Position 3 is a $3,000 sign-on bond pretrial. Position 4 is a $1,000 surety. It's reset to the SAP calendar. Position 5 is a $1,000 sign-on bond jail. Position 6 is a $5,000 sign-up. Was that jail or pretrial, Judge? Pretrial, thank you. Position 6.
Oh, pretrial I have.
Thank you. Position 7 is a $2,000 sign-on bond jail. Position 8, bond remains the same as set yesterday, $2,000 surety bond. Position 9 was reset further notice made bond. Position 10 is a $5,000 sign-on bond jail. Position 11 is a $1,500 surety bond. Reset SAP. Position 12 is reset to tomorrow's SCA calendar, 10/26. The add-on calendar, position 1 was a $1,000 surety bond, reset to MMC calendar. Position 2 was a $1,000 surety bond and reset to MMC calendar.
Any questions about the calendar? If not, just a couple other things. Ms. Falk, if you wouldn't mind following up on position 1 with that jurisdiction issue that I believe Ms. Gant brought up, if you all could look into that.
Your Honor, the state already has, and it is in
Okay.
Fulton County. We used both Google Maps and MapQuest to verify. So it is in Fulton County. So unless there's any information to contradict that, that's what we're going with.
Okay, thank you.
Thank you.
I also have been contacted by, and Mr. Jordan, I don't know if Ms. Lewis, we had somebody on the calendar, I'm not sure when, it's a George Lopez Ramos. Apparently he received
She said she took care of it. She said the updated bond order to the jail. Ms. Lewis did.
okay, well, he has my personal number, has been calling me and has called me on my way here. So I'm just want you to get him off my back.
Okay, yeah, so she sent it, and I forwarded the same email that she sent yesterday. I forwarded
I
that
want
to
to
the.
make sure, his client is out of jail also, so.
Right, okay.
And Ms. McLeod, this is.
Yes, Your Honor. The family has been calling me constantly. The jail is still refusing. I've tried calling the jail. I can't get Miss Hill. I left a message for her, and they still won't let my client go.
Is that from the case that was amended this morning?
Yes.
So they probably just have to process him once they get the paperwork. So right at the court, they would not have received the paperwork. So Ms. Lewis did court this morning. She had to collect all the paperwork to get it all together, get all the judge's signature before she could send anything to the jail. So they should have it now and should be processing.
Okay.
Is there anything the state can do to assist, or is this outside of anything we can assist with?
No, it was just a misunderstanding of time served, first credit for time served. So the sentence needed to be changed. The days that he was supposed to be serving in jail just need to be reduced so he could get a time served plea.
Understood. Thank you, Mr. Jordan.
All right. Thank you all. Anything further?
Nothing further.
Okay, if not, you all have a good rest of your day. I'll see you next time.
Thank you too.
Thank you, Judge.
All right, everybody.